Okay, so buckle up because this story just got really wild. A federal judge basically kicked out Pam Bondi's whole lawyer squad, not just one person, the entire team gone. Court papers from Monday say the judge found some serious problems called conflicts of interest. We're talking 14 different cases, $127 million worth of legal fights, and 23 open matters, all of them frozen right now. This 47-page court order dropped, and honestly, page 8 alone needed 3 reads to understand. Here's what the order actually says. Trump now has 72 hours to bring in a brand new legal team. The deadline is Thursday, March 26th. No extra time, no appeal allowed, just follow the order right now. The papers lay out exactly how this mess happened, and most news channels are skipping the good parts. Quick background first. Pam Bondi is the Attorney General, picked by Trump after some earlier drama with confirmations. So, what's the actual problem? The lawyers she personally chose for the DOJ had old relationships with companies and clients that created what the court called structural conflicts. Here's how it happened, short version. A few weeks back, defense attorneys in 3 big cases noticed something felt off. A few days later, they filed papers asking the court to check if there were real conflicts. By Friday, the judge called a private emergency hearing. Monday morning, this massive order came out. Now, here's what makes this case different from normal lawyer drama. It's not just one attorney with one awkward situation. The court order found a pattern. Same law firms, same big corporate clients, same people passing back and forth between government and private jobs. The judge who wrote this, by the way, was actually appointed by Ronald Reagan, not someone you'd expect to go after a Republican administration. He spent 11 whole pages mapping out this web of connections. And here's the big deal about his language. He didn't say it just looked bad. He said it was an actual conflict. That's a much harder thing to prove in court, and he proved it anyway. Bondi's response so far? A 2-sentence statement saying the ruling was procedurally irregular? That's not a real defense. That's just stalling while the clock ticks. Now let's get into what the documents actually show. First filing from Monday, page 12, lines 4 through 9. The court says the government's lead lawyer kept an active financial partnership in a law firm called Morrison and Keefe while at the same time running legal strategy against people that same firm used to represent. That's straight from the filing, not an opinion. What does it mean in simple words? The attorney who was supposed to be fighting these cases had money ties to a firm that was on the other side, but then it gets worse. Page 31 shows the judge found 7 specific situations where case strategy talks happened within 2 days of money being sent to that connected firm. Wire transfers, $3.2 million total over 19 months. Add those 2 things together, and this isn't a paperwork mistake. This is a pattern of behavior. The timeline inside the order is really something. November 2025, first conflicted lawyer joins the DOJ team. January 2026, a second lawyer from the same firm network gets added. March 2026, a third lawyer who was actually a former managing partner of that same firm joins up. All of it documented, all of it in the order. Here's the part nobody is really talking about. Page 38, footnote 14. The judge writes that Bondi personally approved these hires even after her own department's ethics office, called the Office of Professional Responsibility, gave her written warnings not to. 4 warnings, all attached as Exhibit G in the court documents. The first one, from September 2025, directly names the Morrison and Keefe connection and says, "Don't appoint this person." The second memo in November uses even stronger words, saying keeping these people risks the judge stepping in. The third memo in January files a formal objection. The fourth memo in February says, "We've done everything we can internally. There's nothing more for us to do." That's the DOJ's own ethics office telling the bosses in writing, 4 separate times over months, do not do this. And on page 41, the judge says clearly that the government can't act surprised by this ruling when its own internal watchdog kept screaming about it. So, what's actually affected right now? Three very big cases are now frozen. A massive tech antitrust case with $89 million at stake, a defense contractor fraud case with 41 different defendants, and a civil rights enforcement case that's been building for 2 full years. All of them stopped until new lawyers are approved. And those new lawyers can't have any connection to the firms named in the order, can't have ever worked for any party in these cases, and have to hand over complete financial records to the court. The judge on page 44 basically says, I'm going to watch whoever gets nominated very, very carefully. Translation: don't even try to sneak in another conflicted attorney. And then on page 47, the very last paragraph before the actual order text, the judge says he hasn't decided yet whether to send the whole thing to a bar review board. That's not a final call. That's a warning. The lawyers who got kicked off could still face professional consequences on top of being removed. And that's just the order itself. What Bondi's side is saying and what legal experts think about her options. That's coming too. But first, let's be fair. The other side has some real arguments here, not just spin. Defenders of the DOJ say the judge went too far with his power. And honestly, parts of that argument aren't nothing. Their points go like this. First, conflict rules in law have gray areas. The attorneys had technically already left their old firms. They followed the waiting periods the rules require. Technically, the letter of the ethics rules was followed. Second, yes, the judge was appointed by Reagan, but he has ruled against this administration before on similar procedure arguments. 2 times already. There's a pattern on that side, too. A former assistant attorney general from the Bush years said it plainly. Courts should be careful about blowing up active federal cases over indirect or stretched conflict arguments. That's not nothing as a point. What the DOJ side has going for it, the specific ethics rules that were cited, actually have exceptions built in for government service situations. Other judges in other parts of the country have allowed similar arrangements to continue. Even a Georgetown law professor who studies ethics and is definitely not a Trump supporter admitted the conflict standard this judge used is stricter than a lot of other courts would apply. The point isn't to declare who's right. The defender's take is the rules were technically followed, the lawyers disclosed what they needed to, and revolving door between government and private law happens in every single administration, no matter who's in charge. The judge's take is technically following rules doesn't matter when the structural problems are this deep and when the government's own people warned leadership 4 times. Both of those readings can be defended. That's what makes this legally interesting. Here's where the DOJ defenders have their strongest argument, though: timing. These cases were getting close to really important dates. 2 of them had trials scheduled within 60 days. One had a settlement meeting coming up next week. The defense attorneys who raised the conflict issues, they waited. They could have brought this up months ago. They brought it up now at the exact moment it would cause maximum chaos. That was almost certainly a strategy. The judge even acknowledges this on page 22 of the order. He says the court is aware these challenges came at a really sensitive moment in the cases. But then he says, and this part is key, the timing of the challenge doesn't make the conflict less real. Yes, the defense played it smart. Doesn't mean they were wrong. One more thing the administration's people are pointing to. The judge refused to pause his own order while an appeal happens. Normally, in a ruling this big, the court gives a pause, a stay, some breathing room so the legal questions can be argued further up the chain. Not here. Immediate effect, 72 hours, go. That's unusual, and DOJ already filed yesterday evening calling it procedurally irregular and asking a higher court to step in as an emergency. The appeals court could step in Wednesday or Thursday at the latest and grant a stay. If that happens, this whole order gets put on pause, Bondi's team stays, and everything just covered becomes a legal footnote. That's a real possibility. The ending here is not set in stone. What is clear from the documents, the judge found enough to act immediately and with zero pause. This didn't appear from nowhere. Here's some backstory that's worth knowing. Last fall, early signs appeared about Bondi's hiring patterns. Legal blogs noticed a lot of the new DOJ attorneys were coming from a small handful of connected firms. December, a watchdog group filed a formal complaint with the ethics office and got a standard acknowledgement letter, no visible action. January, 3 defense lawyers in the tech antitrust case asked for conflict disclosures. DOJ handed over partial information. February, those same lawyers filed a sealed request for a judicial review. And someone, a former DOJ ethics official, actually said out loud back in October that the Attorney General was building a team based on loyalty rather than independence. Said it on a legal podcast, barely got any coverage at the time. What happened every time a warning came up? The warnings got ignored, the hires kept going, the cases kept moving forward, pattern conflicted, flagged inside the department, higher-ups approved anyway, flagged by outside attorneys, partial disclosure, proceed, flagged by watchdog group, no response, proceed. Every single time they moved forward until Monday. The judge's order shows he reviewed material going all the way back to September. The list of evidence runs 340 pages. Depositions, emails, financial disclosures, the ethics memos, all of it. This wasn't a quick reaction. He had been building this case for a long time. One detail from the sealed February filing that's now partially public. Defense attorneys claimed they had proof of direct communication between the conflicted DOJ lawyers and their former firm while cases were actively happening. The judge found that claim supported by actual documentary evidence. That's on page 29. That's what pushed this from a theoretical problem to a proven actual conflict. Now, the moment the order actually dropped, 2:47 in the afternoon on Monday. No warning, no heads up to the parties. The clerk's office just posted it straight to the docket. The court hereby disqualifies all government counsel of record in the above captioned matters. DOJ communications went completely quiet for 4 hours. The White House press secretary dodged 3 direct questions. Bondi canceled her afternoon press availability. The lead disqualified attorney's firm said no comment. 4 hours of silence followed immediately by 11 hours before any statement came. Here's what most people missed while everyone focused on the disqualification and the 72-hour deadline. Monday evening, the judge scheduled another hearing. Thursday, March 26th, same day as the replacement lawyer deadline. But this hearing isn't just to look at the new attorneys. The court calendar entry says status conference regarding potential supplemental remedies. Supplemental remedies. That phrase matters. And then Monday night, a new sealed filing appeared. Defense attorneys in the tech antitrust case asking for sanctions against DOJ for how they conducted litigation. The judge ordered a response due Wednesday. So Bondi's remaining DOJ lawyers, the ones who weren't disqualified, now have 24 hours to respond to a sanctions motion while at the same time finding replacement attorneys for 23 frozen cases. That's not accidental overlap. That's pressure being applied from 2 directions at once. The judge's approach here looks very deliberate when you watch the schedule. The 72-hour deadline forces scrambling. The simultaneous sanctions briefing splits the department's attention and resources. The Thursday hearing creates a very public moment. He isn't just removing attorneys, he's taking control of how the whole situation moves forward. And the appeals court still hasn't said anything about the emergency stay request. DOJ filed that at 6 in the evening yesterday. 18 hours of silence from the appeals court so far. The longer that silence continues, the more likely Thursday plays out exactly as scheduled. What legal experts are actually saying? A former federal prosecutor who spent 22 years in the Eastern District said plainly, conflict disqualifications happen, but never like this. Never this comprehensive, never affecting this many cases at once. The scope is unprecedented in recent DOJ history. A legal ethics professor at NYU said the judge's use of those internal OPR memos transforms this from a close judgment call into a clear-cut case because the government essentially documented its own warnings in writing. Without those memos, it's arguable. With them, it becomes obvious. Here's something interesting. Even a former DOJ official who served during Trump's first term said the 72-hour timeline is aggressive, but not unreasonable given what the court found about deliberate disregard of conflict warnings. When people on both sides of a legal argument agree on something, that's worth paying attention to. A conservative legal analyst with Federalist Society connections said the judge may have gone further than necessary on the scope, but the core finding, actual conflict proven through documented warnings, is legally sound. A former assistant U.S. attorney now in private practice said Thursday's hearing matters more than the disqualification itself because supplemental remedies could mean anything from fines to full case dismissals. The overall consensus from professionals is this: the conflict finding is legally defensible even if aggressive. The timeline creates real operational headaches for DOJ. Thursday's hearing could significantly expand the consequences. The appeals court stay decision is genuinely uncertain. That's where experienced legal minds land right now. Why should regular people actually care about any of this? Real talk, money first. If money is invested in any company currently being prosecuted by DOJ, this matters a lot. The tech antitrust case alone involves a company with a $340 billion market cap. Stock moved 3% after the order came out Monday. The defense contractor case has 41 defendants, but also hundreds of subcontractors and supply chains connected to those companies. Index funds hold basically everything, so a 401k might have exposure to these companies without anyone realizing it. Some institutional investors are reportedly pausing positions until Thursday's hearing shows a clearer path forward. Precedent matters too. This ruling will change things in federal courts going forward. The next time anyone is in federal court, civil case, criminal case, regulatory dispute, conflict standards just got stricter because of this ruling. Other judges will read this order and reference it in their own decisions. A simple example: someone sues a former employer. The employer's attorneys used to work for a company that invested in the employer. Connected? Maybe. Under older thinking, probably fine. Under this reasoning, potential conflict. That's how precedent quietly changes everyday legal reality. Who is affected right now beyond the big cases? 23 active federal cases on hold. That's not just defendants waiting for a resolution. It's witnesses sitting under subpoena with no idea when things move. It's victims in the civil rights case waiting for some kind of justice. It's companies that can't close deals because litigation is unresolved. The defense contractor case alone has 41 individual people whose lives are paused while DOJ figures out its next move. And the ripple effects hit federal court dockets nationwide as other judges watch what happens and defense attorneys in other cases consider filing similar motions. By April, there could easily be a dozen similar challenges filed in other parts of the country. Here's the uncomfortable thing nobody really wants to say. Every administration does some version of the revolving door. Government attorneys go to private firms, private firm attorneys go to government, both parties, every era. This judge just said the line has moved. What courts tolerated before is not acceptable anymore as of Monday. For anyone working in law, finance, healthcare, defense contracting, or any regulated industry, assumptions about what's allowed in legal representation might already be outdated as of this week. How did Bondi actually respond? Honestly, it made things worse. 11 hours after the order dropped Monday, a two-sentence written statement came out. The department disagrees with this procedurally irregular ruling and will pursue all available remedies. That's it. No specifics, no mention of the 4 OPR memos, no explanation of how new attorneys would be found in 72 hours. Legal commentators posted thousands of reactions picking apart the non-response. Cable news ran split screens of the silence. Senate Judiciary members got asked directly about it, and the ranking member responded within 2 hours saying, "If the Attorney General ignored 4 written warnings from her own ethics office, that's not a judicial overreach problem. That's a leadership problem." Then Tuesday morning, today, new development. DOJ filed its emergency stay response, 19 pages long, arguing the judge went beyond his authority and created conditions that can't actually be worked within for ongoing federal law enforcement. Strong language, but notably missing from those 19 pages, any denial of the factual findings. They are not saying the conflicts don't exist. They are saying the remedy chosen was too harsh. That is a tell. When a legal filing can't challenge the facts, it attacks the process instead. Classic legal strategy, but it signals exactly where the weak point is. The appeals court still hasn't ruled. 18 hours of silence. The longer that silence stretches, the more likely Thursday happens exactly as scheduled. What is still genuinely unclear right now? First, who is actually available to step in as replacement attorneys in 72 hours? DOJ has a big bench of lawyers, but finding attorneys with no connections to any of the named firms who have the right clearances and who are willing to step into this specific political fire, that is a short list. Second, what exactly does supplemental remedies mean? Thursday's hearing could go several different directions: sanctions, dismissals, referrals to other authorities, or just procedural cleanup. Third, the appeals court could rule any moment. A stay changes everything. Silence or denial makes Thursday the most important DOJ courtroom day of this administration. Wednesday at 5 in the afternoon, DOJ's sanctions response is due. That filing will show the actual legal strategy being used. Thursday at 10 in the morning, replacement attorney deadline and the status hearing both happen. Those are the dates that matter. One more thing worth noticing. This judge has been extremely meticulous about building a paper trail. A 340-page exhibit list isn't accidental. He wanted this order to survive any appeal that comes. That kind of preparation takes time and intentionality. Here's where everything stands right now. Bondi's full litigation team disqualified as of Monday. 23 federal cases frozen pending replacement counsel. Emergency stay request pending at the appeals court with no indication of when a ruling comes. DOJ sanctions response due Wednesday. Thursday hearing scheduled at 10 in the morning Eastern. Potential appellate ruling possible Friday if Thursday proceeds. What is still not public? The full list of potential replacement attorneys DOJ is currently vetting internally. Also still developing, and whether any of the disqualified attorneys will face bar referrals. The judge reserved that decision, but his language made it clear it's under active consideration. The Office of Professional Responsibility, the same group that issued those 4 warnings, has not commented publicly. Their investigation, if any, would be internal, but the judge's order essentially turned all 4 of their private memos into public record. That creates exposure for people beyond just the lawyers directly named. The chain of approvals ran through multiple DOJ offices. The clock is running. 44 hours until Thursday's deadline. This is the biggest judicial rebuke of Bondi's time as Attorney General. On the surface, it looks like a conflict ruling that forces new lawyers in. But the judge's actual language goes much further than just procedure. Deliberate disregard, actual conflict, documented warnings. And Thursday's hearing with supplemental remedies on the table leaves everything still open. The appeals court is the wild card. A stay changes this story completely. Silence or denial makes Thursday the moment everything pivots. The story isn't finished. The Monday order started something. Thursday might close it or blow it wide open. What is known for certain, a federal judge read 4 internal DOJ warnings, reviewed 340 pages of evidence, and concluded the Attorney General's own team had to be removed immediately. No pause, no appeal window. That does not happen often. It happened Monday.